And in this lecture, I particularly want to focus on the non-financial stakeholders who suffer as a result of that. The employees who lose their jobs, the trade suppliers who lose their customers, the government agencies who lose money. And the risk is that all of those stakeholders end up ranking behind a large amount of debt in a business that cannot be saved. And in this lecture, I'm going to say that is socially very costly and something that law needs to take very seriously. It also contributes to what you may have seen called in the press the zombie company phenomenon, a business that is limping along, managing to pay its interest bill by diverting cash from its operations, scrabbling around behind the sofa for every available bit of cash. But it can't invest, it can't grow, it can't increase wages. It is literally limping along, zombie-like. So that's the problem. Now, I warned you there were going to be rather a lot of moving parts. And in order to unpick this problem in the private equity context, we have to start with how private equity funds its buyouts. As this is a very simplified diagram. I'm not very good at drawing diagrams, so I have borrowed one, which I'm licensed to do. And essentially, the point that I really want to sort of hone from this diagram is that the private equity fund borrows, the portfolio company borrows a significant amount of debt relative to the amount of equity investment that goes in, normally divided into tranches. And here I've just got a senior tranche and a high yield or a mezzanine tranche. It uses that to buy the target company. But the vital thing here is that that debt is not staying in the target company. This isn't generating cash for the target company. Most of that money is going to go to pay off the existing shareholders and the existing lenders as part of the buyout. So we end up with a target company with a very significant amount of debt, which is acquisition debt. And that's going to be an important part of our story. So in order to understand the present, the problem, we have to understand the past. So I need to identify for you what has changed, why I say there is a new problem. So shareholders have always had an incentive to avoid a restructuring and financial distress. Because if we think about it, if we have the firm value, whatever the value of the firm is when it's in distress, the first group that are entitled to that are the senior lenders, and then the junior lenders, and only the shareholders when the senior lenders and the junior lenders have been repaid. Now, we'll come back to this. This is going to be important. But that's the broad idea. And so shareholders, when a business is in distress, really risk losing their equity value if they start a restructuring. There is a significant risk that other people higher in the capital structure will capture the equity value. And so for a shareholder, it is always better, most of the time it will be better, to gamble on redemption, to just keep going. Management also largely share that incentive, at least that will do for today. That's a complicated story, what it will do for today, because management want to keep their jobs. And if somebody else ends up owning this business as a result of the restructuring process, they will fear they will lose them. Management also are typically extremely optimistic about the chances of turning things around. They're invested in the business in a more than a financial way. And so shareholders have always had the incentive to avoid a restructuring if they can, and to hope that things will turn around. And this finds formal expression in US bankruptcy in something called the absolute priority rule, which basically mandates that in distress, the junior class can only recover once the senior class has recovered in full, and so on. And so if the firm value at the moment of the restructuring is not enough to cover all of these parts of the capital structure, the shareholders have a very high risk of losing their equity in Chapter 11 in a non-consensual plan where that rule is engaged, so where people have not been able to agree amongst themselves, and where that rule is engaged, there is a very high risk that the shareholders will lose their equity value, their equity stake. But this has traditionally, for most of my life as a corporate insolvency lawyer, this has been countered by incentives from the senior lenders, which were different. Senior lenders do not share that incentive, because if we can restructure the firm, then there is a higher chance that the senior lenders will get repaid. So if the situation deteriorates in the way I've described, if financial distress moves into economic distress, there's a risk that everybody loses. including the senior lenders, because we end up with a business that is really not worth very much at all. But if we restructure, there is a much higher chance that the senior lenders will recover. And senior lenders, for most of the recent past, from the sort of the 1970s, when firms really started to borrow significant amounts of money relative to their earnings, and that's a fairly modern feature. But for most of the recent past, shareholders have had an incentive to drive a restructuring where they sense that the firm is in this sort of spiral. And they've had the mechanisms to do that. So large UK banks had a big back office operation to monitor the financial condition of the debtors. They had restructuring specialists to drive a restructuring if they thought one was needed. And they had covenants in their loan agreements, which enabled them to call the borrower to the table to renegotiate. This is the mechanism that I'm going to argue has changed. And that, I'm going to argue, is the problem. So the new environment. Well, first of all, if shareholders have always had that incentive to avoid a restructuring, that is heightened, I would argue, for private equity firms. And I can't do much justice to this in the time available with an eye on the clock. But I'm going to argue that private equity firms are particularly incentivized to avoid a restructuring transaction. First of all, private equity firms need to keep going back to their investors to raise a new fund. And in raising a new fund, past performance is going to be extremely important for the investors in considering whether to invest in a new fund. And so they have a particular interest in preserving the equity value of their investors where they can. The second point is rather controversial, but they also make, in some scenarios, rather handsome fees from keeping the situation carrying on. And then the final feature I really can't do justice to today, but there is an active secondary market for debt. And if a restructuring starts, it's highly likely that the debt will trade in that secondary market. And there are players in that secondary market whose objective will be to try and come and take over the firm. So for those of you who have any familiarity with takeovers, where we talk about putting the company into play, once there's the prospect of a bidder for a company, we see the company coming into play. You see the same effect now in modern restructuring. There will be players in that secondary market who are trying to buy in with the ambition of taking the firm over by swapping the debt for equity and ending up owning the firm. And so a huge disincentive for a private equity firm in seeing that happening, in seeing competitors coming into the space. Secondly, private equity firms are rather uniquely placed to secure the loyalty of their management by offering other jobs that the sponsor has, by offering other chances, by saying to management, don't worry, if this doesn't work out all right on the night, we have a lot of ways of seeing you okay. And so they also have, and there's a series of papers, US papers on this, Vincent Bicola, Jared Elias, Kramer and Castile, that really identify this, that the sponsor has the ability to say to management, stick with me here. And so the incentive is broadly the same. As I say, shareholders have always been incentivized to avoid a restructuring, but I'm arguing private equity firms have a heightened incentive. But the really significant change for me is what has happened to the senior lenders. So the dominant holders of senior debt to private equity are what are known as collateralized loan obligations, CLOs. So these are securitization vehicles that buy up leveraged, so significant bundles of debt. They buy them up and they issue notes against that securitization. And I argue that CLOs share the incentive of the private equity firm to avoid a restructuring. And this is across multiple dimensions. The first is that the CLO manager, the firm that runs the CLO, receives a performance fee. And that's the exciting part of owning and running a CLO. But the ability to continue to get a performance fee depends on what's called an over-collateralization test. You have to pass the over-collateralization test. If you don't, your performance fee is switched off. Other things happen too, but your performance fee is switched off. Now, the problem is, if a loan enters a default as defined in the CLO documents, it is valued in a different way, and it is valued in a way that makes it more likely that you will not pass the over-collateralization test. And default in many CLOs is quite broadly drafted and would include the type of restructuring that I am saying may well need to happen. So if you enter into that restructuring, then the loan is valued in a particular way that makes it more likely that you will fail the over-collateralization test, at which point your performance fee is switched off. This is not very exciting for the CLO manager, but there are other problems. CLOs really struggle to participate in what's called restructuring and exit finance. Now, again, I warned you there were going to be a lot of moving parts, and exit finance could be a lecture all on its own. But this is the finance that's provided to a company once it's sorted its capital structure out, and it can be on extremely favorable terms. So I sort out my capital structure, raise a new loan, and that can be on very, very favorable terms. And in many restructurings, it will be the most exciting part of the restructuring, participating in that exit finance deal. Now, CLOs struggle to participate in that. They also struggle to participate in debt for equity swaps. So recall my restaurant with too much debt. I said that a very classic way of restructuring it will be to swap the debt for shares, because now I don't have to pay interest. The shareholders only have a right to a dividend if I declare them. I also don't face a maturity problem, a problem at which I have to repay them, because shareholders can't come along and demand that I repay them. And so a debt for equity swap is going to be a very common feature of large corporate restructuring. And that's what we're talking about here in the private equity buyout space. And yet CLOs struggle to participate in those deals. And so for these, and in fact, other reasons that I don't really have time to discuss today, I think that CLOs really lack the incentive to drive a restructuring. And that's the change. Recall that I said when banks were in the senior debt, they had an incentive to push for a restructuring. I do not think that CLOs do. So why is this a problem? Well, it's a problem because what will happen, the alternatives to a restructuring. So I've already talked about diverting cash from operations to meet the debt. So the restaurant just pulls all its cash away to meet the debt, to meet the interest payment, and everything in the business begins to deteriorate. We launder the tablecloths less often and so on. And so actually I would argue that the do nothing option is probably the worst option. The next option is what is known in the market as amend and extend, but rather pejoratively sometimes referred to as amend and pretend, which rather tells you everything you need to know. So in this, we do a deal with our lenders just to be in compliance with the loan. But the problem with an amend and extend transaction, will amend the bits of the loan that we're breaching. But the problem with an amend and extend transaction is it can make the problem that I'm talking about worse. It's likely to require fees, often very significant fees. And in many cases, the interest on the debt will actually go up. And so rather than solving the problem, we've made the problem worse. We've got more liquidity pressure and we've got more debt. We're not deleveraging at all. And then finally, and again, we can't unpack this today, but there are a series of very controversial US transactions, and these are predominantly a feature of the US market, up-tier and drop-down transactions. Now, the only two bits of this that you really need to, I think, know for today is that these involve borrowing more money at a priority level. So you just layer more debt onto the business. Generally, also in return for that, you buy out some of the lender's existing debt and give it a priority boost. Now, don't worry if that's a bit baffling. I don't think that matters. Again, the point is this might reduce cash debt service. It might reduce the interest bill. But if it does, it's often in return for what's known as payment in kind interest, which is a rather euphemistic name for just capitalizing your interest. You just continue to capitalize it. What happens if we do that? The debt is getting larger. So if I'm arguing that what we need here is to lessen the debt load for my restaurant so that it can trade on profitably and grow its business, in fact, what's happening here is that the debt may get larger. Now, the features of this really also depend on the price at which I buy back the existing debt. But there's often not a very big discount for doing that. Sometimes there's no discount at all. So again, if all of that is a little bit baffling, the important point is that the alternatives may not reduce firm leverage, or they may not reduce it by enough, or they might even increase it. And that the risk with this is that the firm enters distress later in a worse state than it was in at the point that this started, and this is socially costly. So I'm going to move fairly rapidly over something that I feel I have to address, which is whether I'm overstating all of this, and I don't think that I am. So these are a series of US papers which are not on this point specifically, but where the argument that is made in the paper, I think, could also be alleged against my lecture. The first is Frederick Tung's work, who said, look, this is all a good news story. This stops firms having to do a really expensive restructuring, paying a lot of fees for the restructuring, and it gives the firm time to sort itself out. Gives the firm a space in which to sort itself out. Now, I think my restaurant example indicates why I do not think that can ever be a complete answer. I accept that in some situations that is what will happen. There are undoubtedly situations where you start a very expensive restructuring, and actually, had you not done that and had you just given the firm more space, it would have been, as it's sort of called rather euphemistically, it would have grown back into its capital structure. It would have been able to cope with its debt. But that, I do not think, can be a complete answer to this problem. I think that there is reason to suspect that the result of this dynamic is that more firms will end up in a worse state coming to the table later. There's also a rather complex argument around what are called split control rights and what used to be called in older literature delegated monitoring rights. And again, Frederick Tung has written about this, but picking up on the work of Grebelin and his co-authors Nini and Edison. This is, sometimes there is a small layer of debt that sits right at the top of the capital structure, a revolving credit facility, and that's for working capital. It's normally quite slim and it sits right at the top. Now, that debt may have covenants in it, which enable the lenders to call the borrower to the table, and it may well have traditional banks as the providers. And so the argument here is, look, that little slither at the top can do all of the work for the rest of the capital structure. The banks can call people to the table in the old way, and they can drive the restructuring. Now, I think there are all sorts of reasons why this doesn't work. The first is a very technical issue with the way that the modern covenants work. They are springing. They are only tested in certain scenarios. And it is not easy, but it is very possible for borrowers to navigate around them. They also often come with a cure right. The borrower has the right to cure the breach, again, avoiding the testing. And there are all sorts of things that in modern debt contracts you can do with that covenant that make it easier to meet, both in the size of that little slither at the top and definitions and various other issues. But absolutely crucially, if all of that sounds phenomenally technical, and it is, and again, I think could be the subject of an entirely separate lecture, the thing I think to hold on to is that the only group that have the right to call the default are the lenders of that very small slither. And if it is a very slim slice of the overall capital structure, things will have to get very bad indeed before I think I'm in trouble. I've got no real incentive to call it to drive anything. If I've lent a tiny amount of money at the top of a big debt stack, my incentive is not really to rock the boat and start demanding some huge expensive restructuring. So I don't think that this does the job. And then finally, there are the incentives of the other investors, and those I'm literally just going to say for today are pretty murky. The incentives of the other people in the capital structure are not easy to unpick at all. And so I suspect you've all been wondering where the law is going to arrive. So here it is. What can and should the law do about all of this? So the proposition is that we need to consider to what extent corporate insolvency and restructuring law should incentivize early restructuring in light of these changing incentives. We have not had to worry very much about this. This is the argument in the paper, because market incentives have done it for us. The argument is that that is no longer true. So what should or could law do about it? Well, the first thing, of course, is what about all of those stakeholders that I've talked about, the suppliers and so on? Why can't they push for the restructuring? Why can't they just pick up the slack? And there are a series of problems here. The first is that these stakeholders have very weak monitoring capacity. The supplier is trying to run their business, not monitor the financial condition of everybody that they supply to. Government agencies have got all sorts of pressure on resources. And none of these groups have the specialist experts that banks would have had in the past. And there are also a series of legal problems, of which the most important is that the principal restructuring tool in English law can only really be driven by the company. It is very difficult for the creditor to drive that proactively. And that is because the creditor needs the company's consent in order to push the plan forward. And so that is, I think, problematic. But in any event, even without that legal problem, I do not think that this is a solution. What about directors' duties? To what extent does our existing directors' duties regime prevent directors from playing fast and loose and pushing a restructuring down the line as fast as they can? So the first is fraudulent and the wrongful trading regime, with which I think almost everyone in this room will be familiar. But the problem is this is not really what fraudulent and wrongful trading is for. Fraudulent and wrongful trading is to stop you trading on at the position of which it's utterly hopeless. It is not really designed to incentivize an early restructuring. The other problem is that fraudulent and wrongful trading claims can only be brought by the insolvency practitioner, who for all sorts of reasons has pretty weak incentives to push the interests of the unsecured group of trade suppliers and customers and so on. Insolvency practitioners are repeat players in the market, and they are, for all sorts of reasons, likely to pay more regard to the interests of the secured creditors than the unsecured creditors. So I do not think this mechanism really works. What about the common law duties of the directors? Well, there are a whole series of problems here as well. So this is the duty of the directors to have regard to the interests of creditors at a certain point in time. The first problem is that the duty is to have regard to the best interests of the creditors as a whole. But this entire lecture is about the problem of different incentives between different groups of creditors. This creditors as a whole concept is very hard. The second problem is that the Supreme Court has recently, and for the first time, considered this duty in some detail, and has ended up with a test where the duty is only really triggered when insolvency has either happened or is imminent, or the company is bordering on insolvency. Now, in the paper that will accompany this lecture, I have strongly preferred Lord Richard's test from my previous in the Court of Appeal. And I promised Lord Richards that this has existed in the paper for long before he was on the scene to chair today. But we are where we are. The Supreme Court has spoken. Now, I said it's a test. It's actually dicta in the Supreme Court judgment. But I don't think that any High Court judge is going to announce that it's only dicta from the highest court in the land, and therefore they're going to make up their own test. So I think this is what we have. And because of this concept of imminence, doesn't really help us with a duty to drive a restructuring. I've put Hunt and Singh on the slide. I don't think I can do justice to that in the time either, but it's clear that the High Court is already beginning to grapple with quite what this imminence idea really means. There are also problems with the meaning of insolvency. At least two of the Supreme Court justices discuss the meaning of insolvency in this concept, and one of them uses a concept of insolvency which pushed this even later, very late. Seems to be a sort of what some of you in the room will recognize as Professor Roy Good's point of no return idea. So again, doesn't really help us with a duty to drive a restructuring. The standard of review is subjective. It's what the directors think is in the best interests of creditors, not the court, unless the directors have failed to turn their mind to the question of the creditors at all. And although creditors can bring a claim directly, there is a procedural mechanism by which creditors can bring this claim. They don't need to rely on the insolvency practitioner. It's quite a brave trade supplier who puts their money behind this sort of claim in a loser pays jurisdiction. That is a pretty brave thing to do. So should we reform them? Should we reform the common law duties to have a duty specifically to think about restructuring? Elizabeth Warren in the US has proposed what is rather colourfully called the Stop Wall Street Looting Bill. And effectively, this bill would make private equity firms liable for the debts of their portfolio companies in certain scenarios. My goodness, that would change the incentives, but it's pretty dramatic. I'm not really suggesting that we throw the entire private equity model out of the window with this problem. So I don't think that's a route to go. Ireland have done something very interesting, and there's a fabulous recent article in the Journal of Corporate Law Studies by Quinn and Gavin looking at this. So they have codified their director's duty in distress. So ours remains a common law duty referred to in the statute. It's fundamentally from common law. Ireland have codified theirs. And in their codification, they have codified a duty to take steps to avoid insolvency. So that looks quite close to a duty to think about a restructuring. You now have a duty to take steps to avoid insolvency. So should we do that in response to this problem? I'm a pragmatist, as most of you in the room know, and I think this is unlikely to make it onto the legislative agenda anytime very quickly, not least because the reason Ireland brought this in is because they are subject to the European Restructuring Directive. And the European Restructuring Directive requires member states to think about this issue, this preventative issue. And so they had a motivation to reform that candidly we're lacking. But even if we were to do this, Quinn and Gavin identify in their paper the problem of bringing a claim for a failure to act. It's much harder to bring a successful claim that somebody didn't do something than that somebody did do something. And so a claim that the directors failed to restructure when they should have done is not a very easy claim to frame. What about disqualification? Well, this is a state remedy. That is quite promising because we're not talking about large trade suppliers and customers and so on taking the action. But again, serious issues here with bringing a disqualification claim, attempting to disqualify directors because they did not restructure early enough. And again, a lot of practical issues here. It is a state claim, and so we are using limited and precious state resources in bringing these claims. And we can't use this in a large number of cases. But secondly, and I'm only going to touch on this lightly because again, this would need a lot more analysis, but there had been some recent evidence of considerably more willingness to bring these claims in large cases. And we've had a recent very high profile example of that, but those cases have not proven very successful, let's put it that way. And at least one of them has collapsed. And I think we have to think about the impact that that will have on the willingness to use this as a mechanism. And there are other issues surrounding that. So overall, what's the conclusion of this moving part? Well, the conclusion is that a well-advised director who takes care to document their decision-making process can navigate the liability risks in deciding not to restructure without too much difficulty. And I don't really end up in the place where I think that some sort of reform necessarily moves this dial. So what else? Is this all hopeless? Well, I don't think it's completely hopeless. We could think about lender incentives. So one of the issues I've raised is, well, what about if you put even more debt on? Should we hold lenders liable who load even more debt onto an already distressed business? Many civil law jurisdictions do this, but there are real problems with that. Again, it's a little bit like my comment about the Wall Street looting bill. The risk is that you throw the baby out with the bathwater, that you make the overall rescue finance environment very difficult indeed. And that, I think, is not a route we want to go down. We have seen challenges to some of the more aggressive US transactions, and we may yet see lenders less willing to take part in those transactions. There are also significant UK challenges with some of those more aggressive forms of financing coming to the UK. And so there are things in the lender space which will matter, but I don't think lender liability ultimately is the way to solve the problem. I do think, and I'll come back to this at the end, that we should encourage the raising of exit finance within a court supervised plan. So as I've said, CLOs find it very difficult to participate in exit financing, and so may hold up a restructuring where that sort of exit financing is vital because they can't participate it, and it's the most exciting part of the plan. Within a court supervised plan, we've had examples recently of the UK courts blessing exit financing deals that give priority to certain lenders. And I think that is something that we want to encourage. But now I'm going to get to the sort of da-da, where I think that we really can make a difference. But my goodness, I think this is difficult. I think in the end, the solution to this is to incentivize the private equity sponsor to restructure, to move the incentives of the private equity sponsor. I think it's very difficult to move the incentives of the CLO, easier to move the incentives of the private equity sponsor. But in order to do that, we have to make it more likely that some equity value will be preserved. Otherwise, this is, to use the sort of the colorful image, turkeys voting for Christmas. Now, I mentioned that in the US, there is a rule that makes this very difficult, the absolute priority rule. So I've used very daft numbers here. I can see some students in the room. They know that I use very simple numbers every week to make sure I don't get my maths wrong. So these numbers are obviously ridiculous, but let's assume that we've got firm value of £350. We've got senior lenders with 500, junior lenders with 500, and shareholders at the bottom. And so the value break is in the senior lenders. There's only enough value to cover the senior lenders. And so in a US Chapter 11, it is extremely unlikely that there would be anything for the shareholders if those were the numbers. Now, there are two exceptions to this, which the US has played with and which we could think about. So we do not have this rule. We do not have an absolute priority rule in our restructuring regime. So just looking at the statute, there is nothing to prevent the shareholders making a recovery. Our only rule is that everybody has to do better than they would do if the restructuring plan didn't go through. That's our only rule. We don't have a priority rule, an absolute priority rule. And so I'm going to suggest that's good, because it means that that risk that the shareholder, the private equity firm, will lose all of their shares is less heightened in our world. But at the same time, I'm also going to argue that we need to be extremely cautious about how we justify allowing the private equity sponsor to keep shares, because otherwise this looks dangerously close to the Wild West. So on what basis, if it's not absolute priority, on what basis do we allow the shareholders to keep their shares? So the first argument that's used in some of the US literature, and which has been used in some of the embryonic UK cases, is gifting. So the argument here is that the equity value in this firm is with the senior lenders. It's not enough firm value to cover their 500. And so the equity value is there, and they can decide what to do with it. And if they want to give it to the shareholders, give the junior lenders nothing and just give that equity value to the shareholders, that's up to them. And that's the end of it. Now, that's superficially really attractive because it avoids, as you'll see in a moment, all sorts of complex arguments. We just need to decide that what we call the in-the-money class, the class that has enough firm value to cover it, we just need to decide who that class is. And then we say, well, it's up to them. If they support the plan and they want to give it all to the shareholders, that's up to them. I'm going to suggest that's hugely problematic. And I do not think this is a route that we should go down. And there are early signs in the cases that we are going down this route. And I think it's hugely problematic. There can be multiple reasons here why the senior lenders want to keep the sponsor on side. You can have all sorts of important relationships with that sponsor that really motivate deal doing behind the scenes. And there is nothing here really that helps us to interrogate where that equity value really should sit. And the closer we get to the 500, the harder it is to say all of the equity value is the senior lenders to do with as they wish. And so if we have no valuation information, and in many of the recent cases we have had very little, and we don't really know what the motivation was for doing this deal behind the scenes, this looks dangerously close to something that can result in all sorts of bits of collusion that I don't think we would want to support. The alternative idea is new value. And here the shareholders keep their equity because they put new money into the business. So again, I've used daft numbers, and here my shareholder is stumping up £500. Now, private equity sponsors can be considerably more incentivized to put new money into an existing situation than an outside party would be. They know what's happening in the case. They may have relationships with other people in the capital structure. There can be all sorts of reasons why they are the most incentivized party to put new money in, but only if you're restructuring the debt structure. Otherwise, their money just sits at the bottom behind everything else, and they risk putting good money behind bad. So this, I think, we do want to incentivize. You can keep your equity, provided you put new money in. You are more likely to put new money in than anybody else. And that money can then be used for multiple purposes. It can be used to pay the fees of the case. It can be used to make cash payments to creditors who you might need to deal with in the plan. I haven't really got that in my example, but you could have. And it can be used to finance the firm going forward as exit finance. And so this, I think, is ultimately the solution. And the route that we have gone down in not having an APR facilitates it. And I think that is all good. However, I think there is a problem with doing this without any valuation evidence at all, without anything that really helps us to calculate whether the amount of money that the shareholder is putting in really justifies them keeping all of the equity in the firm. And again, in some of the recent cases, I think we come dangerously close to that. There are two solutions to that. One is to say you have to go out and offer other people the chance of putting the money in. And if no one else is willing to put it in at the same value, that indicates that this is a fair deal for the shareholders. But recall what I said at the beginning, that is pretty unattractive for a private equity sponsor in a highly competitive world, where it goes out and it starts marketing this opportunity basically to its competitors. And if the problem that we're trying to solve here is incentivizing a restructuring, that's pretty unattractive. And so where I have come out in my work is to say, I think we do have to have some sort of valuation around that justifies the decision to leave the equity for the shareholder in return for the contribution. And that needs to be some sort of post-new money valuation of the firm. We try to look at what the firm will be worth with its new capital structure. And then we try to test whether the amount of money that the sponsor is putting in looks reasonable against that new money valuation. But this is problematic. It's problematic for me because I am on record of saying that these are the kind of valuation disputes we do not want in restructuring. It's problematic because the consultation leading up to some of the legal tools that are used to do this suggests that this is absolutely where the government didn't want to go, didn't want complex valuation fights. It's problematic because these valuation fights are enormously expensive. We've got to work out the post-reorganization enterprise value of the firm, and let's face it, who the heck knows? Very difficult, as many of you in this room know, to work out how well a business will trade after it's restructured. It's completely reasonable for there to be a discount to plan equity valuation. This is rescue finance. You would expect to provide it at a discount. It's perfectly reasonable for the sponsor to say, I should get a big discount here. This is rescue finance. It's dangerous and risky money. How big should that discount be? And the fees that are provided and the backstop arrangements that are provided to the sponsor may build in another effective discount to the valuation. How reasonable are those? So this is not a great place to end up from any of those perspectives. And you can completely see, I think, why the courts are pushing against ending up in this place and preferring either a gifting analysis or a very straightforward, the sponsor's putting new money in, nobody else seems to have wanted to do that, so it's all fine. But here's the conclusion. I think it is the most effective solution to the problem, providing the legal tools that incentivize the private equity sponsor to seek a restructuring. I think facilitating exit finance through that mechanism, so making it more possible to raise new money through that mechanism, I think that's an attractive feature and important. And I think we were absolutely right not to have an absolute priority rule. I think this will create all sorts of problems in the US in incentivizing restructurings where they ought to be happening. But where it come out in the end is that we simply can't do this without safeguards for creditors. We cannot end up in a world where, a very murky world, where we simply say, this is the in the money class and they can drive everything. And I recognize that this implicates the type of valuation dispute that I wanted to avoid, that I think the government wanted to avoid, that I think actually most practitioners wanted to avoid. But where I've ended up is that I don't think we can avoid that. I think it is what it is. This is a pretty exorbitant power, the power to write down people's claims. And in the end, I think where I end up is that it isn't easy, but it probably shouldn't be easy. So many years ago, I was told in a thing on presenting that I shouldn't have a slide saying thank you. But as a result, nobody ever knows when I finish. So I have finished, and these are just the references that I refer to in the slides the other day.
Well, Sarah, thank you very much indeed. I have time in 2 comments. The first is that from time to time I've spent time in the US bankruptcy court for the Southern District of New York, and on my first visit there were 2 cases, 2 Chapter 11 cases I attended. The first concerned Lionel, which was then the largest Chapter 11 case ever in the United States, a huge multinational chemistry firm. The other was a restaurant in the Rockefeller Center, and the particular problem that day was that there had been a leak of water into the French consulate that was on the floor of the day. I think it had been in Chapter 11 for about 4 years. The other thing I just wanted to say was that our lecture today underlines and illustrates the importance of oral presentation. I've had the advantage of reading the current draft of Sarah's paper, which I must say is absolutely terrific, but there's nothing like the oral presentation of the issues and arguments, and you might expect me as a judge. But Sarah, once again, thank you very much indeed for your